My name is Chris Ayers. I'm a shareholder in the law firm of Anderson Kill in the New York office, and I'm here to discuss recovering value for investors in companies that go dark. And so when companies go dark, it leaves investors holding the bag without ever having intended to bear the risk of the company's behavior that's illegal under the SEC rules. Finding recourse can be particularly difficult if the company that goes dark is based in China, where parties tend to be far removed from the normal reach of the U.S. judicial power. So investors find themselves in a very sticky financial and geopolitical situation. Even if the U.S. court were to issue an order to seize corporate assets, there is no direct mechanism to compel compliance in China. So what we've been able to do is we've been able to use judicial means as well as the corporate governance to gain control of the company and use that power to enact decisions which are generally at odds with the management's wishes. So we use the judicial means to allow investors to extract their shares out of the company at fair value and in many cases strategic value. One of the first things when you're looking at a target company is due diligence. It's critical at the early stage of when you're looking at a target to understand the corporate governance documents, the memos, the articles of association, the corporate bylaws. The financials are critical to understand the data points for evaluation of the company, which would help you unlock the fair value. It's essential to understand your investment target's rights and obligations to you. And in doing so, it's critical to understand the filings, the corporate governance filings that have been made in China with the Administration of Industry Commerce, the AIC, any appraisals and other corporate valuations, tax filings, and other financial filings with governmental agencies. And so it's important to do this due diligence ideally before the investment is made. But it's also critical to do this at the stage of when a company has gone dark and you're trying to understand your litigation recourse. And in doing so, you also want to look at the business filings. Who's controlling the entity? You want to look at the real estate, if it has any leases, any debts against the realty. Basically, you're looking for all things of value. You also want to undertake site visits, interview with management, employees, suppliers, and customers. Because in China, it's oftentimes you get into various local government struggles, so it's important to understand, well, does the management have the support of the local governments in China? Do you have contacts with your investigators and other people that you have placed out or have means to be able to put some stress on local governments in order to put pressure on management? So you want to understand the number of employees, and it's also critical to analyze the corporate structure of the entity. We're talking about a traditional WOFE structure where you have the U.S. Publicly traded company with wholly owned subsidiaries in BVI, Cayman entity, and then a wholly owned subsidiary in Hong Kong, and then with the wholly owned subsidiary which actually manages the assets and operations in China. Or is it some other type of structure? The structure will dictate the recourse that you have and how to go out to extract the strategic value. And this is all being done in a litigation analysis, looking at the contingent liabilities, the contingent asset increases, cash flows, likelihood of success. And this needs to be done at the get-go. Look at the intellectual property. What assets does the company hold of value? And again, you want to make sure you understand the players, the management, as well as the ownership interests in the various capital structure. And in doing this, you also want to understand the comparable companies. When you're valuing the entity, you want to understand the comparable companies that you can use in order to price out the shares of that you're holding for your investors. Now, in conducting this, it's important to understand that your best course of recovery is through a corporate takeover rather than from an offshore judgment. And the reason is, the internal affairs doctrine, which most countries, including China, will honor and allow shareholders to exert control over the operating entity through reconstruction of the board into a friendly directors. The courts will not interfere with and will enforce the legal exercise of rights conferred in the corporate governance documents. So it's important to understand if you're able to exercise a takeover through the corporate governance standpoint rather than coming from a U.S. judgment. So from a corporate takeover standpoint, the advantage is you get to remove and replace the board of directors of the company in order to deal, dispose, and control the shares of the company's wholly owned subsidiaries by collapsing the subsidiaries and being able to gain control of the operations in mainland China or wherever they're being held. They're able to vote those shares. The friendly board of directors now able to vote those shares, as well as amend bylaws and operating agreements for the benefit of the shareholders. So it's important to look at, when you're talking about analyzing the takeover scenarios, you look at the rights and restrictions under the investment documents and corporate governance documents. You master the rules and defenses that a company may use to obstruct a takeover, and then you anticipate the paths that the outcome may take. The investment vehicle and the associated deal documents control the rights that you may have and your ability to control sufficient shares effective to remove and replace the board of directors. And so it's important in this circumstance to understand what management and what management rights management has to ownership interests and to control the shares of the company, because you need to ideally control a majority stake in the company, or if you don't actually acquire a majority stake, you can control it via proxy rights of a group of investors. There's also the option, if you have it, to when you take out a substantial debt position within the company, to require the company to put up a majority of equity as collateral. So in that instance, if the company defaults, you would then be able to control a majority of the shares. And then you'd be able to take over the company from a debt position. Again, in doing this, the critical piece of it all is negotiation. And so that's why everything boils down to essentially the term sheet. Now, it can only be 2 to 3 pages, but it could contain all the material terms and provisions that would be able to protect your interests and make sure that you'd be able to control a majority of the shares in order to take over the company should your investment so need it. And so we've been able to, from a variety of standpoints, been able to assist clients from the get-go in order to document the deal structures where they've invested in these foreign companies, such as in China, where they can where if they provide a substantial debt position, they put in enough provisions and enough controls, so where they'll be able to control a majority of shares and be able to direct and replace the directors and ultimately the operations in mainland China. This is just a sampling, but in drafting your deal documents and drafting the documents that will control the investment, it's important to keep in mind a variety of different provisions. And this is why it's important to make sure you have, counsel that's knowledgeable in this realm. These include anti-dilution provisions. It protects investors from being diluted in later rounds of fundraising. I've had clients that have come in after the investment has gone dark. They've come in and reviewed it and say, hey, I own 51% of the shares in the company. And I say, that's great. Let's take a look at the documents. And we take a look at the documents, and it's true. They did. They took percentage of a majority of the company. However, that was 5-6 years ago. What about now? The company has gone through various fundraising and various efforts to raise capital in order to, maybe go public, or basically to dilute, or with the specific purpose of actually diluting the majority owner after they've made this substantial investment. So they were essentially defrauded. Now, there's recourses for that, which we're going to discuss later in the presentation. But these investors were able to have the opportunity from the get-go in order to put these types of provisions in the deal documents, these anti-dilution provisions, liquidation preferences, in order to protect themselves in that circumstances, but they didn't know, and so they didn't. And so as a result, they didn't protect themselves from the company's later bad actions. And so these also include other potential participating preferred provisions, and this allows essentially an investor to double dip, and so to get an additional preference in addition to being bought out, as well as, again, it's kind of similar to the anti-dilution, but where a company is going to go to do another round of fundraising from investors, and it would give you the right in future rounds in order to maintain the same level of ownership that you had, so you wouldn't be diluted. And oftentimes, you have these first rights, and so you can also have a sign-off ability. So if a company did want to raise additional funds, whether it's debt position or equity position, you would put appropriate provisions and restrictions in the deal documents in order to control that process. So no, the company would not be able to dilute you, would not be able to raise additional funds without your consent. Now, when you're talking about corporate takeovers, you have to understand that there are various of anti-takeover strategies that a company could take to make the acquisition unattractive and in other ways prevent it altogether. Now, these measures that a corporation could take are basically brought down into two different categories: preventative measures and active measures. Preventative measures are things in the deal documents which you should be able to understand from the get-go. And so this is going in when you're analyzing the deal documents of whether to actually make the investment or not. But it's also critical when you're looking at, hey, if I'm going to do the takeover, to unlock the strategic value, to exit the investment at fair value and not take your losses. It's important to understand, for instance, there's protections like a staggered board provision. This is a great way to prevent a corporate takeover because you would only be able to replace a certain number of the board of directors in one given year, any given year. So by staggering it, it really limits your ability to take over the company. Oftentimes when we've done this, you have a board of 3, 4, 6 people, and when you're restructuring it, you restructure the board by replacing it with your friendly board of directors. But it's normally what we can do is we can also amend the bylaws at the same time. So you amend the bylaws replacing the board, which maybe has a requirement of 6 board of directors, with a single member who's able to then vote the shares of the U.S. company and then go down the chain. And by doing that, you get to do that. But if they have a staggered board, you really can't. You can't replace them at the same time, and you can't amend the the bylaws to have one acting board of director. There's also supermajority provisions, which can go anywhere from 66% require in order to enact change of replacing directors or amending the bylaws, up to 80%. So really, a supermajority can be a very diverse mix of what they require, but it's important to understand that, and then to understand who controls substantial shares to do it. We've engaged in a variety of places where we've gained in a kind of a grassroots effort to get together sufficient equity interests in order to enact a takeover by going out to the various shareholders. But if management controls a portion, that automatically defeats that kind of grassroots effort to gain a majority or the required number to restructure and reconstitute the board of directors. There's also a variety of other things: dual capitalization, the poison pill, measures to discourage takeovers, and then a golden parachute, which essentially just gives the management such lucrative packages to leave that it just makes it incredibly unattractive to the new people coming in. It's always important to keep in mind, though, that the board of directors is constrained by its fiduciary duties to shareholders, so it can't just look out for its own best interests. And if they do, then that rises to a whole nother cause of action against the shareholders and against the board of directors themselves personally. So, which would provide another avenue of recourse. There's also variety of active measures to take over the company. And these include various green mail, which is always something that we've dealt with numerous times, and is also something that isn't a terrible thing. So when you're in the midst of a takeover, the management obviously finds out about it, and when they do, they provide a payment of substantial premium to the client. So ultimately, because of your takeover, even if you never ultimately intended to take over the operations and replace all of the directors and take over operations and market it for sale and all the things that we're kind of going to discuss in a little bit, if you know that the assets in the company are of great value to the management of the company, then all green mail is oftentimes a great result for you in order to extract at a substantial premium in addition to the fair value of your shares. Then there's also, White Knight coming in, another company coming in to try to take control of the company. Now, so again, in order to monetize the investment from an equity position, so you need to control enough stock to affect change in management. And so you can either control that in equity via proxy rights or outright ownership of the shares in order to replace the board of directors with a friendly one. And then you can squeeze out, oftentimes the board of directors will then squeeze out the minority of shareholders at fair value in order to then, when you market the enterprise as a going concern, it can often be more valuable to a buyer after you've squeezed out the minority. And executing a takeover from a debt position is similar. the ability to do so, again, is going to be dictated by the promissory note and the corollary agreements we'll be providing for the shares that are put up as collateral, permit you to control them with vast proxy rights. And proceeding through these types of takeovers is superior to the offshore judgment because you're not using a U.S. judgment as the grounds to take over the company. So it puts you in a far superior position when when ultimately you take control of the mainland China operations or wherever the main operations would be, and market them for sale through retention of an investment bank and various other means to market it for sale. Now, when you're looking to remove the board of directors, there are two options: written consent, or you can call a special meeting under the government's documents. Now, the written consent is the way to go. You can do it immediately. If you're able to get the votes, you draft up the written consent, and then you're able to execute that written consent by having the members or the shareholders sign it, execute it. It happens immediately, and they reconfiguring the board of directors, approving mergers and other transactions, amending the bylaws. All of this can be done by written consent without formal vote. The other avenue is going by special meeting. Now, the drawbacks of a special meeting are that you have to do it pursuant to the terms of the governance documents, and the bylaws usually will dictate it. And oftentimes, as protective measures, management will put in various notice provisions that can take months to provide proper notice to the stockholders. This delay in getting a special meeting does not exist for the written consent, and that delay can be very prejudicial to your rights to take over the operations. Now, it's important to note that many states do find that excessively long delays in the notice and from the time of the special meeting are unlawful because they'll frustrate the rights of the majority of the investors. Now, it's important to keep in mind when you're executing a takeover, there are a variety of SEC filings and requirements to make. One of the most significant ones is a Schedule 13D and its related blackout period. Schedule 13D is a filing which any investor who owns a beneficial ownership of more than 5% must make. And in doing that, so any time there's a material change in the facts disclosed, essentially the purpose of their ownership interest and their intent, they must make a subsequent filing and disclosure. And in doing that, there then has to be a corresponding 10-day vote consent blackout. So so if you're going to do a takeover, you would need to make this disclosure. That's why it's critical to make sure you line up all of the sequencing of your actions right at day one. And so when you make that disclosure of 13D, you have this 10-day blackout period. You want to make sure you sequence it so that way, as soon as that time is up, everything you need from written consents onward to change the board, to carry out your filings can be done simultaneously, from replacing the board, if it's a Delaware or Nevada entity, replacing that board on that 10th day, simultaneously then going to BVI, replacing that board in Hong Kong. And so you basically, in the same day, have technical control of the operations in mainland China through collapsing the subsidiaries. Also in connection with when you're going from a debt position, you're going to need to make sure you actually have the share certificates. So this means if you're coming from a deposition, you have to replace the collateral agent, have the new collateral agent direct the former collateral agent to transfer the shares, and then vote those shares on your behalf at your direction. Now, important things to look out for, and that we've seen in a variety of instances. Breaking the chain. When we just talked about that the Woofy situation where structure, we have these wholly owned subsidiaries. In order to, you have Shell Corporation, you have a Shell Corporation in Delaware, Nevada, then you have a Shell subsidiary in BVI, a Shell subsidiary in Hong Kong, and then you would have the operations in mainland China. Oftentimes, if they break the chain from the operations in China, it would prevent and impair the takeover opportunity that you would have because there would be this break. And this often is one mechanism management will do in order to prevent such a thing. Now, often these things are fraudulent, so you would have to then initiate various actions related to them. But it's important to understand if they've made these attempts when you're going over, because the management would then challenge your replacement and your reconstitution of the board of directors and board action. And then also transferring the key assets of the operations. The mainland China generally are the ones that have the assets. They're the ones that control the assets. And so oftentimes when you collapse the chain, they will try to transfer substantial assets. Now, we've had many instances where the chairman would personally take a lot of the assets or transfer them to himself or an affiliated entity that he's created. And so then you would obviously, as we'll discuss, you'll have a variety of claims going after the chairman, the board of directors, and a variety of other people. But to the extent that they're doing that in China, your ability to enforce those rights and those claims against them become a little challenging. The liquidity event. It's essential to collect and analyze all historical and current financial and operational information from the company and all relevant marketing data. This is going to be used to allow you to value the strategic position that you've obtained through your equity investment. Now, such valuations can be difficult for companies that have gone dark, but not undoable. And what you find is that you're able to look up comparable companies operating in China, operating potentially elsewhere, that are in the same field and marketplace, and you're able to value those comparable companies and put a price on your shares of the dark company. And then by looking at that, not only are able to value your assets that you have, that your investors have, but also you get to see the potential marketplace. You get to see if there's a strategic buyer out there that can benefit from synergies of joining, of buying the distressed asset. Bless you. So our goal is to put you in a position to sell the company and unlock its strategic value to a buyer that will benefit from the synergies. Or often cases, this is what happens, is you sell the company back to its former officers and directors, to management who want to buy back control. And so the goal is to not only obtain the fair market value, but to unlock the strategic value of the investment. Now, in order to market the company, once you gain control of the assets in China, once you reconstituted the board, and once the board of directors have made its various written consents related to the operations, you want to work with a variety of, and what we do is work with a variety of investment banks that have knowledge and work in China, and work in this space. And so we've had excellent success in selling these offshore companies to either competitors or to strategic buyers. And the process is understanding understanding the competitor lists, and you start to get interest stirred up for the sale. And so the investment bank will put a book together, which you'll put out into the big market, which will basically establish the market for the company, its value of the company, its assets, its holdings, in order to strike up bids and a potential sale. It's very complex, and it's not for the typical law firm or investment bank. And so, as discussed, once you're in control of the board, the board of directors will then merge the top company into a new company and can remove the minority at fair value. And by privatizing the entity, you can oftentimes increase the value in advance of a sale. So that way, the new company would not have to deal with various SEC filings and deal with the issues that arose from the company initially going dark and the penalties and nonsense, essentially, that the company has caused itself. So by merging out, you solve a lot of the SEC filings and filing failures, as well as then you pay out for a fair value to the other investors. Okay, so when you're in a situation, and this is something we've done a lot, when you're in a situation where you cannot control a majority interest of the equity, you can't control a substantial debt position where you're able to get a majority of shares put up as collateral, well then what do? What if you're a 5% shareholder of a company and now all of a sudden you don't have, you're essentially screwed. Traditionally, you would have investment in a company, it goes dark, it suppresses the drop in value. Silence and stagnation can cause value to drop substantially. And so when you're talking about a company that's gone dark, if it was trading at $14, $15, $20, $50 a share, now all of a sudden, because it went dark, stopped reporting the SEC and its violation to its investors and to the SEC rules, now all of a sudden it's trading for pennies. So what do? We've been very successful in instituting oppression litigation in Delaware or Nevada, wherever the companies are incorporated. We've done this initially through the case ZST, which is a major Delaware case, and this is where we basically instituted this process for the first time, and it's obviously been repeated by many others since, but we can say that we were the first. And so in that case, we so the company stopped reporting, was in default, and so we brought a 220 action in Delaware in order to demand the company's books and records and other rights to relevant to valuation. Now, if the company fails to comply with this demand, which they will if they have gone dark, because they have stopped reporting their financial information to the SEC. In that situation, when they do fail to comply with the 220 action by putting up their books and records, then you can commence a formal proceeding in the court to compel the company to disclose its books and records, to comply with your rights, and to seek a judgment compelling the company to do what it's obligated to do under the law and under its governing documents. And if they fail to do it then, you move for contempt of court. And what we were able to do in ZST, and what we've done numerous times since, is here you're able to ask for a broad remedies under the contempt. It's an equitable remedy, and you're able to get broad rights as a result. And in doing so, you're able to, the easy one is the reward of attorney's fees and costs in order to do it. That's guaranteed as a matter of right. In addition, what we've done is we've gotten a put option. So the Chancery Court in Delaware will issue a put option for your investment. The put option will compel the company to buy back your shares. And this is where we're talking about valuation. We'll discuss it a little bit more in depth in a little bit. But when you're talking about valuation of the company of your shares, you basically prove up your shares. And because the company in many instances hasn't appeared in the U.S. court, because it doesn't want to face doesn't want to appear and then obviously fall under the U.S. judiciary's power, you have the ability through your use of competitor data, through the use of marketplace data, to prove up to the court what your shares are worth. And normally this can be substantially more than the your purchase price, so to speak, your cost basis. And so you'll be able to get a premium on the put option. And then with that, you ask for the appointment of a special service receiver. Now this receiver would be able to do what a board of directors would be able to do, control the company. Special service has his right to deal and dispose of the corporate assets and vote its interests. And so similar to what we talked about in the traditional corporate takeover scenario, when you're talking about a receiver, the court appoints it. So that's why it's not as ideal as a traditional corporate takeover, because when you get to China, there are instances where the management may contest the validity of the receiver's actions, given that they all generate and they're all kind of like fruit from the poisonous tree, so to speak. So the receiver would come in to the action, control the Delaware company, then replace by written consent, replace the board of directors of the various subsidiaries and collapse the shells. And take control of the operations in China. And so this is gets the value for the loss, is when you get the receiver appointed, the receiver would then go down the ladder, change the legal representatives in China, and take whatever actions necessary in order to take control from management, despite any type of actions management will take to thwart their efforts. Well, see, the difference is traditionally, if you get the U.S. judgment and you went over to a Chinese court, because many states many countries have reciprocity, so it's the same type of process if you had it in Florida, if you go to New York, or if you went to France, right? You get to enforce that judgment. So in China, you obviously can't take that U.S. judgment and domesticate it in the Chinese court. However, by putting the special service receiver in it, he then takes control of replaces the board of directors in the U.S. company. And so then he follows the same corporate mechanisms and the governance documents in order to take control of the Delaware company, then taking control of each shell. So by the time you get to China, you're taking control of the assets and the operations through corporate governance. Now, you've had various challenges to that where they say, okay, well, it's all fruit from the poisonous tree, so to speak. You have the receiver's only there because of the U.S. judgment. So his corporate action that he's taken is, void. However, we've had success in Chinese courts recently where the Chinese courts have actually accepted the receiver's power in order to replace the directors in order to get that judgment. Oftentimes, but still, it's China. So in various places and so various times, even still, the management won't honor the corporate governance and won't honor their own kind of Chinese courts rulings on that matter. And then it becomes really about who you know. And that's why it's important to have a broad connection of resources. So we've been doing this for a long time. So we have investigators all over the world. We also have contacts with people all over the world. So we are able to, for instance, express and get influence over the local politics, the local mayor who basically runs that province. And so by able to exert pressure over the mayor in order to get him kind of in our pocket, and sometimes it costs a little money, you then have that local politics kind of fight in order to do it. But we've had great success of getting substantial value for the investors. Each deal is a little bit different, but in many cases they've been able to exit the position with strategic value. In other instances, they've been able to take it at fair value of what what their fair value is for their stock, and in other cases, taking a small discount from management buying back the operator. Yeah. Well, what you found is there's fraud going on, absolutely. Fraud on the U.S. market. Each company is different and goes private it goes dark and goes private for its own special reasons. There was an instance where we represented an entity that went dark, but we represent investors against an entity that went dark. But in that case, the entity actually produced a product that harmed the public. So in China, it would the product actually killed various people and stuff like that. So imagine like Gatorade all of a sudden, producing a bad batch and causing a lot of harm. So that actually caused that company to be distressed, caused it to really have its operations in China be harmed. And in that instance, though, there was manufacturing, there was real estate, there was all sorts of other avenues of assets that we're able to take control of and then sell to. For instance, the real estate they had was valued at U.S. dollars over $50 million. So, and so you could take that real estate. Now, granted, then you have to, with real estate, because we had control of the real estate, but then it is the question of local politics. In that instance, we were able to exert pressure from them because we had contacts with the mayor of that province in order to actually be in control of that, in order to dispose of that. So in that situation, we actually did get substantial value, but not strategic value for that. So they did take, in that instance, they did have to take percentage on the dollar there, but in that case, it was a very distressed asset. Other companies, it's actually more valuable to the Chinese company to be private than it is public. So the idea isn't that the operations in China aren't strong and that it's actually a distressed asset. It becomes a stressed asset for U.S. investors because they've gone dark and there's a shell corporation with no assets, and then you have no reciprocity, with the courts in China. So it becomes distress for us. But for China, the company is still some of these companies are multi-million-dollar, multi-billion-dollar companies that are still very active in, there's mining companies. That's, guess what? There's still a whole host of gold, silver, and variety of other minerals that they still have access to and rights to. And so that there's value to all of their operations, and they're still in business and doing well. They just felt, as a result of a lot of the fraudulent reporting that occurred out of various Chinese companies that went public in that around that 2012, 2013 timeframe, that it wasn't valuable enough to them to stay listed on the U.S. markets. So these companies are many of these companies, and each one's a little bit different scenario, but these companies do have value, and they are very valuable. And the management of them wants these companies. So, for instance, there's the Sino Clean Energy, for instance, is a recent one. That company, the investors made a boatload by going back and being able to sell the assets back to the back to management. So each case is a little bit different, and that's why it's important to do the due diligence to understand what they own, who is the management of the company, what percentage of interest do they have, what is the marketplace. I mean, are they making real products, or is it more of a service industry? Services are obviously different, right? I mean, Anderson Kill, it's a law firm, right? So I mean, so if you took control of it, what do you have? You have a bunch of lawyers. You don't have any assets, don't really have anything. You have some rent. So if it's a service company, then clearly that's going to make it much more difficult to extract a lot of value, because the lawyers can go elsewhere, and they can a lot of shenanigans go on there. But if they have real hard assets and and a brand name, that's where you look at the IP and the various other interests. So in many instances, when we're drafting up these documents, these deal documents, to allow these private placements or however the people, the investors, go into these deals, if we're drafting it up, we make sure that we protect the investors in that sense, so we're able to unlock the value of that intellectual property rights and all of that stuff. In many cases, for instance, in a recent case that in one of the companies that we represented the investors as well as the broker-dealer who did the private placement in a company that went dark while they're going on, right prior to them going public. They went dark, but what we were able to do is we took a substantial debt position with the right to convert into equity over time. But what we made them do is we made them take a substantial portion of cash, which is like 80% of the investment, they put into a bank account that was held in BVI. And the convenience part of that, it wasn't in the US, so it was a negotiation standpoint, but it wasn't in the US, so it benefited the company. But at the same time, it wasn't in China. Getting money out of China is the hardest part. So even if you're able to come to a deal with management to buy the money for, even if you're able to get a settlement where you're able to actually unlock a lot of value for your investors, it still is a challenge to then get that money, the cash from China into the US. You can do it through a variety of means. We've actually found the best and easiest way to do it is through small amounts over time. So we'll have the management. We have a bank relationship with a bank in China that has a Hong Kong branch, and then has a small branch in New York City. And so we're able to, by small amounts of the money, they transfer to Hong Kong, and then from Hong Kong it is so much easier to get it over to the US. So by various ways you can do it. There's also, you can go through the government, which is a lot of ways is how, the traditional way to do it. But that, they could say no, they could put a substantial tax on you. It could just take 6 months to a year to actually execute the withdrawal of capital from China. So that becomes an obstacle as well. So structuring the deals of actually how to get the money out of China is a whole nother presentation in and of itself. Now, one of the other aspects to it is that, when you're talking about these companies that have gone dark, generally it's because that have gone dark, stop reporting. You point their special service receiver. There are a variety of different ways to go, but oftentimes it's the board of directors, it's the managers. They're the ones that have instituted the conduct, right? So they're the ones that are also personally liable for defrauding investors. And so in all instances, you're able to look for U.S. targets. And in those situations, you can find bank accounts of any board of directors members, any management members. You're able to then execute turnover petitions in order to get attached to those bank accounts and get those monies right away. You can also go in on ex parte seizure orders for books and records. Those can be incredibly fun, where you actually execute a raid on an accounting firm or another type of representative of the actual entity. And you would actually, when you execute the raid, you would be able to get the books and records of the operations, usually from a third party. And you can use the U.S. Marshals to do that. So this is where you talk about basically different valuation models. This can be pretty important when you're talking about valuing the company. So, and the good part about it is this. You can value the company in all of these different ways and find out which best suits your investors, which best suits you, and then put that before the court. The court generally will take your expert and your understanding of the value comparables of the various companies in issuing the share price. And that's what we'll then use as when it orders the put option in order to force the company to purchase your shares. And this is where you look at similar controlled companies engaging in similar areas, and you look at all of the AIC financials and operations and other data. This is also where you would want to make sure you talk to management. You want to talk to employees, do site visits to understand what they actually have. Recently, we did a restructuring of a Canadian mining operation, which was a shell company for assets from mines held all over Asia, and we were brought in during the restructuring phase where the note holders where they defaulted on the note holders. And so we got brought in by representing the note holders, substantial debt positions, in order to restructure the company in order to get it. But what we did what we found out is that nobody actually went out and looked at the mines before this investment was made. So they didn't understand the mines actually were there, that they said they were there. And so they were basically essentially a bankruptcy proceeding in Canada. And the receiver who was put on the case actually never did anything to substantiate whether these mines existed, whether they were viable, or anything of that. They just relied on these foreign entities, the subsidiaries, to report to it and inform the Canadian courts what actually was there. And so we then used our investigators again to go out and actually investigate the mines. And what we found is that the management of the mines had not basically developed these mines in an appropriate way. And so we were expected, in the restructuring process, they were expected to take pennies on the dollar, so to speak, now in order to restructure for this later. But we found as the mines had very little value left because they basically took all the good stuff right off the top without actually developing the mine. And then what that meant was a strategic loss to the investors over time because of poor management. So we're able to basically, because we found that out, we're able to then bring actions against the management and bring them in order to increase the value that the debt holders obtained during the restructuring process. So it was important to do your due diligence and value the enterprise. There's always somebody, an officer, a director, somebody in the company, control person, even though it's a Chinese company that's held on the U.S. market. Usually there's one or two control persons that are in the United States, subject to the U.S. judicial system, with assets that are in reach and they're living in plain view. Oftentimes we had a manager who was located, he was a Chinese board of director, but he had a house in California. And so by doing our due diligence on the board of directors, we found out when he would be visiting his property. And so we waited, instead of executing on the property, waited until he would actually be there. And then we sent our constable to serve him right then and there in order to get the person in the U.S. And once they were able to serve him, we were able to get him subject to the U.S. judicial system. He had to appear. We were able to obtain his property as collateral, and move to put liens on it and obtain it So from doing that, we're able to basically we got management involved, and we're able to come to a very lucrative settlement with the company by controlling the management's properties. So such people in the U.S. are oftentimes great resource to obtain capital, but also information. So there was a CFO who also lived in the United States for the company. And so we're able to do a seizure, do a raid and seize the CFO's books and records for the company. And from there, we're able to understand bank accounts, information where it's held all over the world, and in order to go over and then do turnover petitions in order to actually execute on those. And then, I mean, the officers and directors generally in the situation where they've gone dark, you can hold them accountable for misleading and fraudulent capital raise with investors to getting onto the U.S. market. And so oftentimes these board of directors are solvent targets in the United States to recover your investment. This is just one example of a case where we're able to, with management, go after management for a variety of causes of action and find U.S. bank accounts, U.S. properties, U.S. assets in order to execute and recover substantial amount of monies for the investors. Broker-dealers. Oftentimes, broker-dealers can be a very viable target to recover losses for these investments for companies that have gone dark for a variety of circumstances. Generally, in a self-directed account, you control your own investment strategy. You dictate where the money should go, and the BD, the broker-dealer, should not interfere with your right. And it's a contractual right you have with the broker-dealer that they don't interfere with your strategy. Execute your strategy. So in many situations with these companies that have gone dark, where sometimes the BD did not fulfill their duties and buy and execute the trades that you've asked them to do. And they prevented the client, the investor, from acquiring the percentage of shares and continuing their acquisition as they would have. And so the BD would be liable to the investor for thwarting the takeover efforts. So in this situation where, for instance, we represented investors it was a thinly traded company, so it was on the pink sheets. It was a Chinese company, and in the midst of a takeover of the company, in the sense where they actually were just buying shares via their broker-dealer, the broker-dealer stopped and prevented them from completing the share. So instead of controlling a majority of the interest in order to take over the operations and control of the company, they are now left with substantial, but less than majority, so less than control. And then by the time everything got figured out, the company obviously prevented the client from taking over. And that obviously put them in a very weak position where now they had millions of dollars stuck in a company in which they lacked control and any avenue of recourse in order to extract, to get out of the investment. And so the broker-dealer was a viable target for recovery. The other avenue is and oftentimes this happens when a broker-dealer places an investor in these products, in a structure, in an investment that's thinly traded. The company goes dark, and oftentimes they just haven't done the proper due diligence on the investment, with promises of high returns, and high yields on these investment opportunities that are held abroad. The investors, the investment advisors, the broker-dealer hadn't done proper diligence on this risky investment. They're not suitable for all investors. So there's a variety of ways in order to go after the broker-dealer and the investment advisor in the circumstances. Maybe possibly the investment wasn't suitable, meaning that the person wasn't actually qualified to be put in such a risky investment. There weren't proper strategies and put in place for the investors, but also there wasn't due diligence being performed under what would happen if they did default on its obligations, if it did go dark, what would happen, what kind of management control do they have, what is the corporate structure, where are the assets held. If they didn't perform the proper due diligence and put you into an investment, that can be a serious problem for the gatekeepers. There's also unfair fairness opinions. Oftentimes public companies, and these can be Chinese companies, or they can be other variety. I mean, this isn't limited. They want to put in a scheme to deprive holders, investors, of value, and that's by looting the corporate coffers. And this is by various assets of transferring them to related affiliates or friends and family. And by doing that, they do it by obtaining fairness opinions, so under the veil of legitimacy. But if it smells bad, it smells bad. And so bankers, lawyers, they can be held accountable for writing opinions that bless the fair market value for transaction that aren't in the best interest for the investors. Oftentimes these agreements that oftentimes management will take are tended to strip the company of value. And so you would have rights in order to bring a variety of litigation to recover for the fraudulent conveyance. And so you can prevent them from stealing the value of the stakeholders. So if you find that assets were of less value than you originally led to believe, then there's recourse against accountants, auditors, and underwriters of the transaction. And these are all solvent, US-based targets. Accountants sign off on the public filings of these companies under Sarbanes-Oxley, and you relied on those. And the investors rely on those seal of approval when they're making investment decisions. And so they're subject to applicable securities laws and common law. And then similar rights exist for underwriters that have represented that it did certain due diligence on the investment. And so ultimately, if the company and management turns out to be a sham, you're going to have a rights against the gatekeepers, underwriters, accountants, and auditors. These are all targets that are in the U.S., all targets that are solvent, that are able to have insurance, and oftentimes you can usually resolve these matters without protracted litigation. Questions? Okay. Thank you very much. If anybody would like a copy of the presentation or anything, you can email me and I can email you a copy of it. If anyone wants my business card, it's also available up here. Oh yeah, absolutely. There you go.